Appearance for the record, please. And strike that, wait a minute, SP 150-08721. Appearance for the record, please.
That one ours?
Yeah.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
You're your own attorney. You're an attorney registered by the state of Michigan.
You don't practice to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date, or you want the office in the back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm challenging jurisdiction.
Trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those positions?
It's not a debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am in this case.
Okay.
And I deny that motion.
Why you deny the motion? Because you don't have.
So, Mr. Hicks. You're a grown man. Let's have a few seconds. Wait a minute. Let's have a few second conversation, okay? Now let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one, wait a minute, you were the one, Mr. Hicks, that said, oh, you can say all that while you're on the bench. Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes,
yeah,
I did.
I thought about that.
You don't even have a
I
license
thought about
to
that.
practice law.
Listen, this
You
whole
don't have a license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to
talk?
You really want to do this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer, or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you. Everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right to. No, you don't have a right to either or.
Yes, I do. Of course, I do.
All right. I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on, and I'm going to put you out, or at least mute yourself. All right. Are we ready on loud?
The court convened in the matter of the state of Michigan versus Mr. Albert Heimer Hicks. Case number SP 15-8721, to address procedural and jurisdictional issues raised by the defendant. At the outset, the defendant refused representation by counsel, stating unequivocally that he would speak on his own behalf and act as his own attorney. Upon inquiry by the court, the defendant confirmed that he was not a licensed attorney, nor registered to practice law within the state of Michigan. The court then cautioned the defendant that while self-representation is a right, it does not exempt one from the rules of procedure, decorum, or jurisdiction governing the court. The defendant repeatedly declared his intent to challenge the court's jurisdiction, asserting that the presiding judge lacked legitimate or delegated authority, and that no lawful jurisdiction existed over him. The court advised the defendant that any such challenge must be made in the form of a written motion, properly filed and argued according to law. The defendant refused, insisting that a verbal objection was sufficient and that the court had no authority to require otherwise. The court, maintaining order, ruled that it indeed had lawful jurisdiction over both the subject matter and the defendant. The judge cited the laws of the state of Michigan, the Constitution, and procedural rules confirming the court's authority. The defendant continued to interrupt and contest this position, accusing the judge of violating his constitutional rights and threatening to file federal civil rights claims under Title 18, Section 242, despite repeated instructions. The defendant persisted in interrupting the court, accusing the judge of practicing law across the bench and denying the existence of any injured party or criminal act. The court denied the defendant's oral motion to dismiss, explaining that his arguments lacked a legal foundation and that the matter before the court was properly within its jurisdiction. As the defendant's behavior became increasingly argumentative, the court issued a stern warning that further interruptions would result in a finding of contempt of court. The judge then presented the defendant with two options: accept the plea offer currently on file or proceed to a jury trial, for which the court would set dates for motions and filings to be made in writing. The defendant insisted that he had the right to choose between a bench trial or jury trial, to which the court responded that the matter would proceed only by jury trial, as the court would not entertain a bench trial under the current circumstances. Throughout the exchange, the defendant maintained that no crime had been committed, that there was no injured party, and that the entire proceeding was illegitimate. The court rejected these assertions and reaffirmed its authority and intent to proceed in accordance with the law. Ultimately, the court concluded the hearing by denying all of the defendant's motions and instructing him to choose between accepting the plea or preparing for trial. The judge reiterated that the courtroom is governed by law and order, not by personal interpretations of jurisdiction. The record reflects that the proceeding ended with the defendant still contesting jurisdiction, and the court proceeding to schedule the matter for trial as appropriate under Michigan law, so ordered.